Okay, so welcome everybody to Garden Court Chambers. I'd like to start off by introducing our speakers. From Garden Court Chambers, we have Nicola Braganza KC. We have Ollie Persey, who is a barrister here at Garden Court. We also have Abigail Wright from the National Deaf Children's Society. And we have David Buxton, who's the Chief Executive of Action on Disability. Thank you to all of our panelists. I'll give you a bit of information about them just before they speak. Just to say from the outset, the event is being live streamed and it's being recorded. The recording will be uploaded onto Garden Court's YouTube channel, and the link and the slides will be sent to all of the attendees this evening. I also have to read you our fire safety announcement. And just to say, after we have the panel event and the Q&A, we'll be having food and drinks in the hub downstairs, so we hope you can join us for that. A really good networking opportunity. So this event is being brought to you by Garden Court, our community care and discrimination law team. The point of this seminar is to bring together specialist public law and discrimination practitioners and trainers to explore the barriers that deaf communities face in accessing justice and enforcing their rights. Specific topics that we'll cover tonight will include identifying breaches of legal duties, enforcement of legal duties, including the Equality Act 2010 and the Accessible Information Standard in the National Health Service sphere, the practicalities of bringing a legal challenge, including the funding and costs relating to doing so, and using the law to inform advocacy and campaigning. So our first speaker this evening is David Buxton, who is, as I said, the Chief Executive of Action on Disability. David, who's been deaf since birth, is based with Action on Disability in Hammersmith and Fulham. He spent 25 years in charity management and local government, senior commissioning sectors, and was previously the Chief Executive of the British Deaf Association and is currently a board member of the European Union of the Deaf. He was Britain's first ever deaf BSL elected borough councillor in 1990. And he was then again later elected as borough councillor and has stood for Parliament 3 times. He's the co-founder of the Liberal Democrats Disability Association, which was set up in 1992 after being 2 years as the disability advisor to the late Right Honourable Paddy Ashdown MP, leader of the Liberal Democrats. He's now the chair of the Epsom and UL Liberal Democrats and is the first ever deaf BSL using person to lead the local political association. Welcome, David.
I'm going to carry on.
Okay, well, thank you very much for inviting me here this evening. I think in my recollection, this is the first time that deaf people have been within a barrister's chambers for an event in relation to the law. So thank you very much for making this event happen. I think this is a historic first. And of course, thank you very much to Matthew Banks. We've lost a good interpreter. He's now changed profession and become a barrister. So I'm looking forward to staying in touch with him and seeing how his new career progresses. I'm sure he'll be filled with challenges, but nevertheless, I look forward to seeing how it progresses. And thank you very much for inviting me this evening. The reason I was invited was to talk about being a deaf claimant against the government in court. I'm not talking about the law. I'm not here to give legal advice. I'll leave that to the barristers, I think. They're much better placed to answer your questions. I'm not a lawyer in that regard, but I do want to talk about my experience within the legal system, my experience of the legal system in the last 15 years. And there are 3 issues that I want to talk about. First, about the access to work cap, that was a policy that was enacted in 2015. So I want to expand on that. Secondly, about access to the elected office fund, if you want to be a parliamentarian or a councillor, and how you get access to work funds for that. And then also becoming a deaf juror. So those are the 3 issues that I want to talk about this evening. So the reason why I decided to engage in a judicial review was because that for many years, in relation to access to work, deaf people have not had any cap on their funding, and funds had varied depending on the deaf person and their position. And then suddenly the government introduced a new policy capping how much deaf people could be given, and that was capped at £43,000. And that really affected my role as the CEO. That affected me and the everyday work that I tried to engage in, for meetings, for networking, for making phone calls, for having conversations. 43,000 was about half of the budget that I had previously received. And so, you know, for interpreters, they need to have co-workers, so you can't just book one interpreter often for many events. And so it was a shock to me that the budget would be halved in that way. So that cut significantly affected me and my ability to perform my work. So that's what instigated the action. The government's perspective was that the employer should be able to make up the difference as part of the reasonable adjustment framework. But my organisation was BDA at the time, and even that Action on Disability now, they are not-for-profit organisations, and they're not in a position to be able to fill the shortfall. So clearly that puts me in a position where I could be given notice for not performing my job well. So that's why I wanted to take the matter to judicial review. I'm very grateful for the EHRC for funding that action, funding the barristers and the solicitors to enable that to happen. I can't tell you how much, but I can say it's a six-figure number, so not an insignificant amount of money. I started working with Louise Whitfield, who worked at Dainton, Pearson Glynn. And she was very experienced in relation to human rights and equality. And she now works with Liberty. So they're a well-known human rights organisation. So she then brought in a barrister who was Sarah Hannett, KC, from Matrix Chambers. So not the chambers we are in today, but one of the top 10 nationally, and as is Garden Court Chambers. So fellows in the top 10. So the process really from starting the process to the end of that process took 18 months. We went to the Royal Court of Justice, not far, just down the road from here. But I want to talk about my experience really going through those 18 months. It was really challenging. And I'd like to say thank you to Nicola Braganza who's here today for the support that she gave me through that process. I mean, for me, I felt that this was a really hearing thing. As somebody grew up as a deaf person, part of the deaf community, it's a little bit alien to our experience. It was very draining, going back and forth, talking to solicitors and then talking to the barristers and then having to answer questions and then having more and more meetings. You would think that it might be kind of a seamless process, but often the government would challenge them. They'd receive papers and they'd say, no, David can read English, for example. David can talk okay. So the CAP doesn't disadvantage him in any kind of way. He can cope. And obviously you're having to then respond to that or get your legal team to respond to that. And that can be very overwhelming. The irony, of course, is the people involved in this process were people from Access to Work who knew me and had previously given me this budget. I'd talked to them many times. They knew what how I worked. They knew that I was a sign language user. They knew that I worked with 2 interpreters. But the process was really kind of adversarial. So it's very similar with any kind of employment tribunal or educational tribunal. You know, it feels like it's just a constant barrage of ways to try and ensure that they win their case. I mean, I can read, of course. I'm not denying that. I can write fairly well. I'm literate. But they knew my situation. They knew that I didn't need English support as part of my job, but I needed interpreters so that I can engage in all of the face-to-face activity that I engaged in as part of my job. So I'd have a 10-minute meeting somewhere, a meeting somewhere else, And so obviously I needed to book interpreters for all day, every day. That's just how it works. That's what the arrangement was, and an arrangement that they previously agreed was how my support needed to happen. So there was often focus on the policy. The challenge wasn't about the policy, it was personal. They were challenging me. And that's also something which was very challenging in and of itself. I've never really experienced that kind of level of legal action. And so when you think of us as deaf people, you don't realise it feels very, very personal. You have to develop a very thick skin, be quite resilient, and that kind of went on for 18 months. I had great conversations with Louise and Sarah, my solicitor and barrister, great team. And I know there are solicitors with us today, this evening, but it was very good discussions. But I mean, for me, I thought maybe it was about individual rights, PSL user. We know that there'd been the Equality Act in 2010, and they were always saying, no, that's not the legal situation. The policy cap is lawful. So the question is how we challenge that. We ask whether the policy is fair or not. So it wasn't about me, it's about whether the policy was fair or not. And the policy itself was discriminatory. So in lots of ways, that was the crazy thing. It was all about reasonable adjustment, which is again not how I thought it would go. I mean, I can talk to some of you if you want to know that in greater depth later, but it was just kind of a process which was very different from what I imagined it would be. It was a real eye opener. As an individual engaging in this process, I thought I'd have to stand up in court and argue my case, as it were. But that's not what happens in a judicial review. You sit and watch. You watch the barristers, my barristers, arguing my case, and the government barristers arguing their case. I thought I'd have my chance in the witness box to say whatever. That was not the case at all. It was really watching those arguments play out. And you see there were 6 big bundles of papers with all of the evidence that we were bringing to bear. And that's how the barristers prepared for the situation. Different issues to do with the law, things which I really had no comprehension of. It was very highbrow. I spent 2 days in court observing the proceedings, 2 full days. Just let me go back a little bit. The cap was 43,000, as I've said. And obviously, 2 weeks before the court was due, the government sent me a letter saying they decided to move the cap up to 56,000. And then they were hoping that I would drop the judicial review. So I talked to my barrister and my solicitor, and I was like, and I was like, no. And they were like, no, this is different. I said, my funding starts from May and goes till March for 10 months. But that's not 1 full year is more than that. It will be 63,000. So I don't want to drop the case because it's still not, I said, it should be 63,000, and the government was saying, oh, it's 56,000. I was like, look at the paperwork. That's not what the number suggests. And then 2 days after, there was an announcement that the cap had gone up again. Everybody was delighted. But really, it was because of this action. It wasn't because of the campaign. It was because the government were having their feet held against the coals. And that's the principle, I think. We know that historically deaf people have claimed for discrimination against different institutions, and they've all been settled outside of court with money. There was no case law to establish how to do these things, which meant that, in discussion with my barristers, they were like, if you're looking at the case law, you can't turn around and say, well, these were the arguments, this is the case, this one. They wouldn't have been able to bring up my case to actually argue for further cases. which meant that deaf sign language users would have no case law. There's historically been nothing. So mine was the first time that a case was established. That's why, you know, if you stand on your principles and you stand firm, then you have to accept that money is not the issue. What you're wanting to do is establish case law, go through the whole process so that then you have something which can be referred to later. It established that legal precedent. And the case law for deaf people is, since 1950, there's maybe been 3 or 4 issues which can be used in case law. But if we think about race discrimination or sex discrimination, there's a huge body of work that can be referred to. So from that experience and, you know, challenging the government, you know, I remember the judge in court. It looked like it was reasonable that the government would win. If there was no gap at all, then I would win because it's not reasonable. They were talking about the gap between the cap and what had previously been awarded. That was what they were, they allowed me to then bring a case about disability discrimination, and then I had to go to the Court of Appeal. I was skint by then. Remember, I mentioned 6 figures. 3 minutes, okay. But that's why that experience of pursuing that journey was significant for me. And then just to briefly mention the other 2 things in terms of access to the elections fund. This was agreed in 2011. And that means that if you wanted to stand for Parliament, there are funds which means you can have your accessibility needs met. But that was dropped in 2015 after the election. There was no explanation as to why. And again, I challenged that and brought action. The government said that they would bring it back, bring an enabling fund in 2018, but it only lasted 1 year before the general election in 2019. But we need to do something about that because that was a temporary measure. That means I wouldn't be able to stand in Parliament for a 4th time without having significant funds outside of public funds. So that's significant discrimination, I think. And then the 3rd and the last one is about a deaf juror. Many of you know the history back from Jeff McWhinney when he brought legal action, and then they said they would look into the policy, and then that was kicked into the long grass. So what I'm trying to say is, I mean, I got a letter calling me to go to jury service. When I arrived, they said, oh, no, just me. Everybody else was dismissed. And I said, I can serve on a jury. And I put my arguments in terms of reasonable adjustment, the Equality Act, etc., wouldn't be a problem. And then I was asked to delay that for 6 months. When I came back in 6 months, they said, you know, you can't, there's only 12 people who can be in the jury room. So that then meant that I could bring an action. An action could be brought. And then 2021, I had discussions with the government, and that's when we had the new law. But there's no case to say that I was wrong, but the Equality Act was superseded the Juries Act in 1975. So that's why in 2020, we then had the new law, which was really great. And so the final thing I'll say, the 28th of April, 2022, I was there in the House of Lords. None of the deaf people knew about the Deaf Jurors Act coming into law. We knew that the British Sign Language Act was passed in the same year as well. But the Police Criminal Courts Act actually mentions the fact that deaf people are able to sit in juries as well. So I got the double and my 2 days in the House of Lords. Thank you very much. I'll end it there.
Thank you very much to David. Very interesting to see what his experience is with litigation and pre-litigation, and some interesting issues for us to think about in terms of the accessibility of that process. Our next speaker is Abigail Wright, who's here from the National Deaf Children's Society. Abigail was called to the bar in the year 2000, and having practiced privately as a barrister in the areas of negligence and personal injury, housing and property law. Having become a mother to a child with complex special needs, Abigail developed a practice in SEN, special educational needs and disability discrimination law. And Abigail has worked for the National Deaf Children's Society, the NDCS, since 2015, where she works as its legal consultant. Thank you, Abigail. Welcome.
Yes, as Matthew said, I'm the legal consultant at the National Deaf Children's Society, and I support the work of a wide group of teams. We try to support children from 0 to 25, so children and young people, and the core of our work will be for individual families working in trying to support them through the assessment process for education, health and care plans. Which is easier said than done and gets more challenging, it seems, every week at the moment. So we have, broadly speaking, the work I do is split into 3 different categories. So we have the individual level of support. We also work to challenge local authorities, primarily when they are proposing cuts to specialist services, such as teachers of the deaf. We're seeing some suspicious policies at the moment. So particularly educational psychologists is an area of particular concern and a real obstacle for children getting what they need. And then there's often proposed closures of specialist units and so forth. So we'll look to work challenging those issues. And then also more broadly, perhaps more rarely, but also on a national level, we'll look to challenge injustice and lack of access for deaf children and young people there. So starting with the sort of individual family basis, that work obviously has got its own really important value in itself, supporting each family as an individual. But when we have such a sort of vast number of cases, those cases are also useful at highlighting much wider issues of impact. And so sometimes quite an innocuous case can come our way, but actually at the end of it, working through and supporting it and offering the best legal support that we can, sometimes through pro bono partners, we then manage to sort of have a much wider impact from what was originally quite a narrow issue. So, like I said, there's a large number of our cases are the SEND appeals, which are not unique to the National Deaf Children's Society in our work. But as I'm sure you would have heard in the national news at the moment, the issue of resources is becoming so acute that the area we do to support families in securing provision for their deaf children before they've managed to secure an EHCP, which is short for Education, Health and Care Plan, and after they've secured it and they've got the document but they can't actually get in place what they're legally entitled to have, that work seems to really be increasing to quite a significant level. Across the board with special needs, resources are obviously a really acute issue, but arguably the difficulties felt even more keenly with deaf children and young people because it's a relatively low incidence disability. So you can argue the legal rights and what a deaf child should rightfully have in their education provision. But if there is such an acute shortage of specialist deaf provision or a decreasing number of teachers of the deaf, they seem to be, the rate of retirement, they're not being replenished at the rate they need to be. So arguably those difficulties are felt even all the more keenly by the families that we support. So what we do in sort of the worst cases, where we can, we try to support those families with pre-action work. We usually work with pro bono solicitors on that case. And what we're doing there is, because they haven't got their right of appeal at that point, often really still in the early stages, things aren't happening. We try in the right cases to work with families and with public law solicitors to draft pre-action letters. So that's really, I'm not going to want to tread on the toes of the more able speakers you're going to hear later, but it's the first step in challenging local authority failings. And if you can really if you have the ability to really plough a lot of resources in at that stage and get those letters really watertight and really detailed, sometimes, not always, sometimes that can be sort of the key that unlocks the local authority focusing on that case. And finally, providing the assessment, the plan, whatever stage it is in the process, providing that for the young people. And as I said, that seems to be an area of work which is just really is on the up. With regard to the local authority challenges we have, legal challenges is really the last resort. And so, because in our organisation there's a vast array of sort of talent and roles, and so we have local engagement officers who try to, as the name would suggest, engage in a sort of amicable way with the local authority, challenging them on where policies that might not be working as they should do, sort of trying to shine the spotlight on the needs of the deaf children and young people in the area. But we find that the most effective work that can be done is when it's a sort of when we work together. It's all about sort of the planning, and the minute you sort of detect that there might be a problem, sort of not, as I say, not going all full force legal, but at that point we try to sort of talk to each other in the team, think where the failings might be. You know, we might get wind of something happening and we're concerned that a local authority is not carrying out a public consultation properly or at all. And so if we can get sort of everything in order at that point, sometimes at that point seeking in the very early stages public or specialist advice from pro bono solicitors, we sort of have a plan of action. And so even in the early stages of correspondence with local authorities, when we really are trying to be positive and work together, it can be useful just to have an eye, like worst case scenario, just thinking a few steps ahead. What do we need to have in place now? What do we need to challenge now to try to avoid it getting to even contemplating a judicial review later down the line? And as I said, those issues can be latent cuts, policies that we're concerned about, and so forth. The third category, on the more broadly on the national level, I suppose we did a sort of quite a lot of work during COVID, because there was obviously the very sort of reactive steps which were taken with masks, which obviously had a really bad impact in schools and across the board in other areas of children's life. So we did work with different national bodies there. Some required more sort of nudging than others. But yeah, we explored, there were places where reasonable adjustments clearly hadn't been made, and really the impact of the deaf children hadn't been considered. So yeah, that was probably a spike in that work, but that's always something we've got on our map if we need to use it. And as I said earlier, it's often like the individual cases, the little ones which come along, which then can have the wider impact. So another area which is on the up is parents coming to us really frustrated about the lack of support that the children have outside of the school hours. So it can be sort of the wraparound care, the after school clubs, those things which are really denied to the children, either the school itself or different sort of well-known national clubs for children, which you would think would be have deep enough pockets to provide the interpreter support that's required. But we've had some real challenges with those, with successful results. But yeah, on a few occasions we've reached out to other partners and worked sort of alongside the Equality and Human Rights Commission, who provided support. So sort of a dual-pronged attack on those issues has finally got the results that we wanted. So they're sort of the three core areas where we look to work. I think my work in itself has a particular focus on looking at where we can be strategic, and so where those cases, wherever they might rise from, do provide strategic potential. Sometimes they come, as I said, come across our path just from one case. Other times we are looking at our overall strategy and our areas of focus, and we're on the lookout. We know the point we want to make, but we need to have the right case to prove it. So the first step is actually us needing to think about, does the law exist? And is it just the application of it which is poor, and that's what we need to challenge? Or actually, are we in a position where we really need to work to try to change the law in some respect? And that won't just be from a legal aspect, that will be with the campaigning colleagues as well, who will be lobbying for that as well. And so currently our sort of focus at the moment is really looking at the importance of the appropriate support for deaf children in the early years, which presents many challenges because before the age of 5, the battle to get the education provision is even greater. But that's what we're looking at. So although with any case that comes across our path, we will review to see if we can help. We're sort of currently on the lookout for the right case. And when I say the right case, it's ones we're looking where the facts are particularly strong, particularly shocking. And so that would be the first thing we look at, because the danger from us as an organisation is we want to pick the right case, because if you get a negative judgment, that can actually be more harm than good in trying to make the point that you're trying to make. So we look at that. And then one other aspect, which I know Ollie's going to cover, so I'll just briefly mention, is we sort of consider when there's a big strategic case, how it's best to fund it. So one option is through legal aid. And in that case, we then not only do we have to have the case of the right facts, depending on which point of law we're challenging and how widely legal aid is available, sometimes we have to find the right family who we think will be eligible for legal aid to be able to pursue that case. But there are other avenues, and we often we've got a good sort of network of pro bono partners and firms and chambers that we'll work with on different cases when it's the right time. But I suppose from our work as a children's charity as opposed to a law firm, we're really conscious, we sort of look at the cases more holistically and in the round. And so the legal work that we do and the campaigning work we do are just elements of the support that we try to give the families and the children themselves. So we're really keen to make sure that they have that wider support, because obviously legal challenges aren't without significant stress and concerns. So we want to make sure that if we are offering that as an option to families, that we can sort of hold their hand through the process and recognise the human and daily impact on lives, which are already stressful. So yeah, I think it's a case of, we work to try the least sort of legal challenge we have to make the better, because that's ultimately we just want the children and to get that provision as soon as possible. But as I said, with the climate that we're in at the moment, it seems to be more and more sort of the necessary last resort that we have to turn to.
Thank you. Thank you very much, Abigail. It's really interesting to have seen it from a deaf litigant and now to see what's going on in the charitable sector across people that we support. Plenty of challenges. Our next speaker is Nicola Braganza KC, who is a barrister here at Garden Court Chambers. And Nicola is recognised as a leading barrister specialising in equality and discrimination law, public law, and human rights. Her broad practice spans areas of employment, education, community care, immigration, and asylum law. Nicola also sits as a fee-paid judge in the first-tier tribunal, the Special Educational Needs and Disability, and in the Employment Tribunal. Thank you, Nicola.
Right. Hello, everyone. Thank you very much for coming this evening. And thank you, David and Abigail. It's really interesting to hear about what you were both speaking about. I'm going to tell you a bit about the Equality Act and also share with you some of my top tips that I have found from running discrimination claims. So the first half will be about the broad concepts under the Equality Act and the types of discrimination claims that you can bring. And then the second part, more practically, what to have in mind. So how do you frame a discrimination claim? So broadly, I've set out here your headline starting point. So what is the protected characteristic? What is the protected characteristic? So in these cases, it would be disability. What is the treatment your client is complaining of? That's obviously crucial. Is it a particular instance? Is it a policy? Is it a failure to do something? So you need to identify what it is you're complaining about. What is the relationship between your client and the person who you are concerned about has discriminated? So what's the context in which it arises? Because that decides what type of claim and in which court or tribunal you're going to bring that claim. So again, linked in with that, the next point, who is liable? Will this be a private law claim? So for example, would it be a discrimination claim in the employment tribunal? Will it be challenging policy and a discrimination claim in the High Court as a judicial review? What type of claim will it be? Will it be a services claim in the county court under Section 29, which of the Equality Act, which is in respect of services? Will it be to question whether there has been proper analysis about the impact on groups with particular protected characteristics? In other words, has the public authority complied with what we call the public sector equality duty? And I'll come to that a bit more in a moment. And that under the Equality Act is the Section 149 duty. So has it had regard in formulating a policy, in making a decision? Has there been an equality impact assessment, for example? Has someone addressed their mind to how this might play out and whether there are particular groups who will be disadvantaged by the particular decision or policy? Also really important, because the time limits are very short, be aware of your time limits. So if you're challenging a policy by a judicial review claim, so the claim that David was speaking about, there is provision to consider a claim that is brought later than 3 months, but you don't want to find yourself in that position if you can help it. So that's really, really important. And if you are out of time, another really, really important, I can't stress this enough, equally, don't be put off. So I have brought a lot of claims that are very late, but for whatever reason. But don't, if you think that there is something in your claim, then don't let the time factor. I mean, obviously, if it's years, then it's going to be difficult. But if you think maybe you can't bring it via another client and this is it, and provided the delay is not too severe, if you have reasons to explain the delay, ultimately it's a matter of the discretion of the court. So when you are presented with a possible complaint and you think we might be in difficulty on time, immediately think, address your mind to, well, how could we explain the delay? So have that in your mind at the beginning. Right. Protected characteristic, for disability, you want to go to Section 6. I've put the definition there. I have quite a lot of slides, I'm afraid. So the idea of the slides is that you have a source to go to. I won't read out in detail every slide. So that's section 6. The next point about identifying the prohibited conduct. So it's crucial. It's very difficult to understand the different concepts, and that's what I'm going to be telling you a bit about. But you have to, at the start, be prepared to work out which you roughly think it falls within. The other point as well, like the time point, very often a claim about the same circumstances can be presented under different equality law concepts. So again, if you're not sure, have in mind you can rely on it in the alternative. But it is important to understand the differences. And it's also important, particularly because of the public sector equality duty, because it requires that the decision maker or the public authority has regard to eliminating, that's the first part, eliminating discrimination. So you have to understand what discrimination is to be able to then say, have you actually considered this properly? So that's the other important aspect of understanding the different concepts. So the first, direct, let me just hit the time. Have I got till, is it till about 7?
Yes.
Okay, so direct, the big difference between direct and indirect is direct is you treated me differently because of my disability. So I am deaf, this person is not deaf, this person got this opportunity or this benefit and I didn't, and the only difference between us is the disability. That's direct. Indirect, if you want to look at the definition, and the most important thing with these concepts is always go back to the definition, go back to the Equality Act. Indirect is a bit more complicated, which is that everybody is treated in the same way, whatever it is, a policy, action to do something or inaction, a requirement is set out. It applies neutrally across the board, but it impacts disproportionately, it impacts in a different way. It puts certain groups at a disadvantage. It puts a group at a disadvantage, it puts your client at a disadvantage, and then there's a last bit. The person who is imposing this decision or policy is unable to justify it. Those are the very sort of core ingredients. Victimization is very important, the next concept, because it's all about providing protection. Again, protection to combat discrimination. If someone else does anything, it's very widely phrased, if they do anything for the purposes or in connection of this act, so they say, well, you discriminated this person or you discriminated this group, and they are then disadvantaged because of it, this section 27 gives them protection. And then you have disability-specific discrimination. So that is, if you want the definition, go to section 15 of the Equality Act. Now, this is really helpful, and a lot of discrimination claims are actually brought under section 15 because it's a concept, it's a difficult concept to explain, but essentially it is, you did something or you've set out a policy which means that I've been treated unfavorably. It might not immediately look obviously discriminatory, but it's connected in that way because of something arising from the disability. So there's like a chain reaction. There's one way I think is quite a nice way of well, for me, it's a nice way of sort of visualizing it. Is it's like, you know, you throw a pebble into the water and it's got all those ripples, and the ripples are all caused by the pebble. And that's the way I see it. And section 15 is very much about, well, actually, the ultimate effect might be the very outside ripple, but you can connect it all back to the disability. And so you connect it all back. And then if you can't show that, again, it's like indirect. If you can't show that it's justified, you will win your section 15. And then reasonable adjustments. And again, reasonable adjustments, I think, is almost the easiest to make out because you have to show there that there is what under the Equality Act, is a provision, criterion, or practice. So something is put in place, it puts the disabled person at a substantial disadvantage. So more than minor or trivial. It's a low threshold. And in relation to that matter, that means there's a duty to take reasonable steps to avoid the disadvantage. So that's section 20. When you look at the Equality Act, you read section 20 with section 21. So this is the second part of section 20. And just briefly, I'm highlighting there, look at 27, which says the person who is subject to the duty, so the person who has to carry out the reasonable adjustment, is not entitled to require the disabled person in relation to whom they're required to comply with the duty to pay any costs towards it. And the failure to comply with that duty is section 21. Remedies, you want to go to section 119, you can get compensatory remedies, you can get, depending on the type of claim you've brought, orders to either quash the decision or the policy, to look at it again. And then in terms of monetary compensation, the starting point is what we call the vento damages. And that is described as the injury to feelings damages. And that gives you an idea of the amounts, if it's a one-off event, or if it's very serious, a campaign of discrimination. And then section 149, briefly, it's a procedural duty, but it is so important. And if you, particularly in terms of policies that are being implemented, or what David was speaking about, and also Abigail, in terms of ensuring that proper regard has been had to the elimination of discrimination. So that's section 149. I've put the main case there, which sets out the principles or the guidance, so the guidelines for it. I've quoted there a case called MXK, and it was all about, it was to do with the Home Office's detention policy, detaining people at the airport when they had an NHS impact. And one of the complaints was, well, they haven't, looking at this policy to detain, they didn't consider the impacts, the equality impacts. And what the judge there said was, in this case, so I'm reading the second part of the bold, there is no evidence to show that the Secretary of State or any official has ever considered the equality impacts of her use of the examination and detention power. So that's really important when you get a, when there's the beginnings of a challenge, to ask those questions. Where is the equality impact assessment? What have you done to address your mind to this aspect? And that all falls under section 149. I've set out there the definition. So what is required under the public sector equality duty? I'll just go to my tips now because I don't have very much time left. So section 149 is also about advancing equality of opportunity, not just eliminating discrimination. Steps to take account of the disabled person's disability, the steps involved in meeting the needs of the disabled person that are different from the needs of persons who are not disabled, in particular steps to take account of disability. So that's under section 1494. Fostering good relations is also what the public authority is required to have regard to. And then I've set out there who it applies to, so those exercising public functions. And then let me get to my, Bracking is the case that I was speaking about that sets out what the equality, what is involved with the public sector equality duty. And again, I won't go through each point, you'll all get the slides and it's set out there. Right, tips, top tips. What is it your client wants? May I have like a couple extra minutes? This is actually, I think this is the much more important bit. Okay, what does your client want? What do you want? What do you want to achieve? What do you want to make sure is not put in place or is put in place? How do you want to change what's being proposed? So that's your, I mean, I always think of cases like this. What's your end point? And then work back from your end point. Raise it early. And this, I think, ties in with what Abigail was saying about no one wants to go to court. I mean, obviously we don't mind. But generally, I always say to my clients, you don't want to go to court, don't ever go to court. And one way of never going to court is to, right at the start, to raise it, to question it, to press whatever it is you're wanting to challenge. Because the other thing about court, as we all know, is that you get all sorts of judges. So you might have a strong case, but you might get a judge who doesn't agree with you. So there is an element of lottery within that. I don't know whether I should really highlight that, but it's a reality. So if you can sort it out, if you can address it early, please do that. Exhaust any internal routes that there might be. And if all those early proactive steps, if they don't work or they don't produce the result that you want, you've got it as contemporaneous evidence. So later on in your litigation, you can say, when they suddenly come up with a document saying, oh, we did this all along, you can say, well, hang on a second, back a year ago, we asked you and you said there was no information on this. So that's my first top tip. Oh yes, and also this goes back to what I said at the start about time, because you can then say, look, we took action very early, and the point about time is there prejudice? Because a decision maker can say, well, you've only just asked us now about it. If you're allowed to run your claim, we will suffer prejudice. If you've raised it very early on, the prejudice argument is going to be a very difficult one. Right, tip 2. I keep saying probably my biggest tip in my slides. So this is one of probably my biggest tips. Make subject access requests. I think Ollie is also going to speak about the freedom of information requests, because they can't say no. There's a time scale to comply with it. Very often they're late, but you can only benefit. In so many of my cases, we've made a subject access request. And then a few months down the line, we've made another one. And we've been given different versions of things. Yeah. So it's interesting. Plead it right and clearly if you can. So when you're framing your case, identify, this goes back to what I was saying at the start, identify what it is you're specifically complaining about. I've put, if you have specific quotes, remarks, all the better. It's very hard to counter. That will depend on the type of the discrimination claim you're bringing. Put things in the alternative at the start, because at the start of litigation, and you will know this if you've been involved in litigation, when you look at the start of a case, you look at the end of it, it's like it's changed into a completely different entity. So it's good to make sure that you've laid your ground and not just pinned your, what's the phrase? Whatever, the mast, the flag. You've done some, you're not too committed to just one particular route, and preempt any time points. Fourth, and I've got then 2 more. Thank you for the extra time. You can never get enough disclosure. Also my biggest tip. So even once you're litigating, that's what I'm saying. I've got a lot of big tips. Even if you get disclosure, go on asking for disclosure. Particularly in a judicial review challenge, there are certain tools that claimant lawyers have which are of enormous value. And one of those tools is the requirement for the parties to litigate with a duty of candor, which means your decision maker has to cooperate with you and the actual phrase used is cards face up. Now imagine, no one wants to really litigate with their cards face up, but they have to do that. So you don't be satisfied by just being told there's just this document. Keep pressing and keep reminding them about the duty of candor. Tip 5, 2 more. Be patient. I said when it all comes together, I think I'm speaking now a bit selfishly as a lawyer. It's a thing of beauty, but in a legal sense, but be patient. Litigation is a strange creature. So I'm just going to give this one example because I'm so happy about it and it happened this afternoon. A year ago, I was involved, I brought a claim, it involved discrimination, it went in front of judge number one and judge number one said, there's nothing in this. And the client got very upset and she didn't want to pursue it. So then we got a second client, we went in front of a judge. So this is now the second judge on the same point. Judge number two, no, nothing in this. Then we went in front of judge number three, and we were saying that the Home Office had a discriminatory policy and the Home Office regulations were discriminatory. Judge number three said, yeah, maybe. So this afternoon, we got a letter. The Home Office is changing the law. It's changing the regulations. It caved in. So, which I know I'm so happy. Thank you. I'm so pleased. So, you know, and I think David was saying this, don't be put off. If you think that there is something wrong, I mean, obviously, if nobody else thinks that, you know, then maybe not. But generally, if you think that there is something wrong, you know, push it, press it, because like I say, in this case this afternoon, I had two judges telling me, no, there's nothing in this. And now the Home Office caved in. So that's why I say litigation is a strange creature. Don't be bullied in correspondence. You might be up against it's all recorded. So you might be up against all sorts of different lawyers. Don't be bullied, stand your ground to the end. And my last point is, at the end of the day, equally, there is only so much we can do. But as long as we make sure we do that, then, you know, it's difficult. It's difficult to win on these challenges. And you get knocked back a lot. And then every now and then you get something great and it makes it all worthwhile. And what I think, you know, for the clients as well, or most clients, it's the most awful. I mean, I think this is a little bit about how David was describing it. It's the most awful experience. And that's why I always say to my clients, don't go to court. I mean, it's stressful enough for us as lawyers. So for the clients, but it is an opportunity to represent their voice and bring across what has happened. And if you've done that, you've served your client well. And if you win, even better. So thank you very much, everybody. Thank you.
So our next speaker is Ollie Persey, a barrister here at Garden Court. Ollie has a broad public law practice focusing on the rights of children, asylum seekers and migrants, and disabled people. Ollie has expertise in discrimination, education, community care, mental health, and court of protection matters. Ollie frequently advises deaf and disabled people's organisations regarding public law and equality law issues, and represents deaf children in the SEND tribunal. And I'm very pleased to say, Ollie is also learning British Sign Language. So I wish him all the best with that. Ollie, over to you.
Great. It's a real privilege to be in this room with so many people who are done amazing work in this field. And I'm very lucky to be following on from the previous speakers. I am going to try and pull everything together with some silly pictures to explain how you can get a case off the ground and some sort of big picture points about actually how the nuts and bolts of bringing a claim work. So I'm just going to briefly go through the topics, and it's not going to be particularly detailed, but it will hopefully give you a flavour of how you actually get the case together. And I'm only speaking about the type of case that David was talking about, the sort of policy challenge, the challenge to a public authority. So I'm going to go through what is judicial review, who can be the claimant, how the important point, money, funding and costs, which I know can seem really scary, and everyone sort of said, "Oh, it'll be really expensive, shouldn't even think about this." Evidence gathering, and Nicola's very helpfully covered some of that already, so I'll be very quick. And then actually how it links in with campaigning. So we've had a sort of masterclass from David and Abigail already, so I'll go very quickly on that point. So a judicial review is a legal challenge brought by a claimant, and it's against a decision or a continuing failure of a public authority. So a local authority, we heard Abigail talking about cuts that local authorities are making to send provision. It could be a school, a state school. It could be a central government department. It could be a university. Anybody that's exercising public functions or is a public authority can be your defendant. It could be an NHS trust. Think about a whole range of ways that you interact with the state or parts of the state. This is what judicial review is about. It's a claim in the High Court, which can seem extremely scary, I realise. You have to move quickly, and this is what Nicola was saying, because there is a time limit, and sometimes you can get a clever lawyer that can argue your way out of it, and sometimes you can say it's ongoing problem, so they're not 3 months from a specific date, but it's an ongoing problem. But speed is a good idea in this context. If you see unfairness, get on it and speak to a lawyer quickly. There are really powerful remedies in judicial review. You can get a mandatory order, which the court can tell the public authority they must do something, and quickly. And if the public authority doesn't do it, that can be a criminal offence. A quashing order, it can get rid of regulations that are unlawful. It can quash a decision by a public authority, say to expel a kid from school. It can say you can never do this again. It's a prohibiting order. And it can declare saying, look, this was unlawful. And that in itself is powerful. This was discriminatory. This was a breach of someone's human rights. And it's important to know, and some of the examples David gave are really powerful examples of how it affects not just the individual, but so many more people by judicial review. It's a really powerful tool for system change. I did warn you that there'll be silly photos, and this is definitely an American one. But it links back to what David was saying. Yes, court is scary, but in judicial review, as Nicola says, you don't need to go to court if you don't want to. You're not going to be in the Old Bailey like a criminal trial. In a judicial review, it's quite lawy. It's quite a lot of barristers speaking, and a judge asking the barristers questions. So that's a way of managing it for you. If you don't, your evidence can be in a written down document called a witness statement. And in a judicial review, you can sort of, whilst it can go on for 18 months and it's stressful and all of the things David said, you're not going to have that trial that can seem so scary. And it's your lawyer's job to try and insulate you from that. So normally no cross-examination. If it involves sensitive personal information about you, you can apply for anonymity. And so, for example, if it's to do with a deaf child, being a minor generally gets you anonymity straight off the bat. And as I was saying, talking about points of law, rather than sort of very detailed facts. Facts come into it, but it's not like a criminal case, kind of stuff you will have seen on TV. Sorry, another silly photo, but hopefully it sort of drives home the point. Law is complicated, but when you're challenging discrimination and by judicial review, I think there's a basic smell test. If it smells fishy, like there could be something in it. And you don't need to think about all of the technical arguments. You don't need to be a lawyer. If it feels wrong and it smells fishy and it feels unfair, it's the lawyer's job to put that into a ground of challenge for judicial review. It's not your job. If it feels like, if it's inside feels, look, this feels wrong, go and speak to a lawyer. Because it could be potentially a human rights breach, an Equality Act breach, a breach of a statutory duty, a failure to actually listen to you, like failure to consult. If a school's being closed and you go to that school, like maybe you should have been consulted before that decision was made. So you don't need to know the grounds of challenge. You don't need to be an expert in the law. But what you do need is to have a good sense of, does this feel wrong? And if it's fishy, then maybe speak to a lawyer. So who can the claimant be? So David's presentation was a really good example about the Access to Work Act. He was affected by that. He had what's called standing in technical language. And he could therefore go and challenge it. If it had just been, whereas I couldn't bring that claim because I wasn't affected by the Access to Work Act. So you need to have a think, actually, who is going to be the claimant? Because they need to have standing and they need to be affected by what's happening. It can't just be a random person off the street. Makes sense. A charity can be a claimant. It doesn't need to be an individual. And sometimes it can only be a charity that's a claimant. It might be that as soon as a lawyer gets involved, the problem is fixed, but there are loads of people who can't access a lawyer. So maybe the charity needs to step in and bring the claim. The money question and why this is so intimidating and maybe shouldn't be. So legal aid, you probably heard there's not very much of it, or it's really hard to get. All of these things are unfortunately true. However, there are a few things to note. One, if you're on any form of passported benefit, such as universal credit, you're very likely to qualify for legal aid. So if anyone's on universal credit, very likely to get legal aid. There is a real complexity around legal aid for children, which is not well understood, but it's worth thinking about. So legal aid is split into two parts. There's something called legal help, and then there's something called having a legal aid certificate. Now, the legal help stage is when you send your letter before claim. Now, for a child, that's assessed on the parent's means as well as the child's means. So unless the child has a trust fund, and many sort of disabled children do have some form of maybe a personal injury related fund, but if they don't have that, and you get through the pre-action stage, maybe with the help of a pro bono lawyer, you can get what's called a certificate. And at that stage, they only look at the child's means. They don't look at the parent's means. So that actually is a big gateway to opening up access to justice for children when challenging it. If there's a policy challenge, there's also a special type of legal aid called investigative representation. And that is a form of certificate. So if it looks like there's a complex issue to do with children, your solicitor might be able to go on to what's called investigative representation really quickly and don't need to do pro bono work. Approach one of a good public law legal aid firm, and you can find those out by Googling. There are lots, there are still quite a lot of them, and there are members from those firms in this room tonight. So maybe speak to them later. There's the Equality and Human Rights Commission, who funded the Access to Work challenge that David mentioned earlier. They have funding to fund important challenges to do with equality. There's a new funder called Law for Change. I would recommend Googling them. And full disclosure, I'm on their advisory panel, so I'm sort of a bit of a cheerleader for them. But they are there to plug the gap where legal aid isn't, where there's potential to use the law to change things for the better. Crowdfunding, there are some ethical issues with crowdfunding. I wouldn't crowdfund anything until you've spoken to a lawyer, at least once. Cost capping orders, well, cost protection is what I really want to talk about. And sorry to have to sort of boring, it's a lot about talking about money, but legal aid means that you're shielded against the other side, having to pay the other side's costs if you lose. If you don't have legal aid and you're going in by yourself, your potential, the rule is loser pays winner's costs. So even if you have pro bono on your side, you may be at risk of paying the other side's expensive lawyers. So you need to have cost protection. But a lawyer can advise you on that. There are things called cost capping orders that limit the risk. And those funders that I've mentioned on the screen quite often provide that protection as part of the funding agreement. Evidence gathering. Again, sorry for the slightly silly photos. And Nicola has covered quite a few of these points already, so I'll go quickly. What are the impacts of decision practice that you think is unlawful? So actually, just think the wrong thing that's about fishy. Have a think. What is it that's bad about it? Try and write it down. Is it I can't access education? Is it I can't actually access work? I'm being cut out of my job? What is it? What's the impact? Who else is affected? Is it just me? Is it other people? Is there any data or other statistics that you could use? Has someone done some research on this? Is there a charity like Abigail's that might have examples of others in this situation? Could they maybe provide a witness statement to say how widespread this is? Subject access requests, Nicola's covered. There's also Freedom of Information Act requests. Certain public authorities are subject to the duty to respond to a Freedom of Information Act request. Could you get your MP on side to ask a question in Parliament? That can be really quick and effective and better than a Freedom of Information Act request that can get really delayed. Try and get your MP on side to ask a question. Is there something that you think the defendant is hiding from you? And this is Nicola's point, really. Like, they're meant to have their cards face up. But actually, do you think they are telling the truth? Keep prodding from different angles. And judicial review as a campaign tool. So actually, the person there is Louise Whitfield, who was David's solicitor. She now works at Liberty, and Liberty is challenging some protest regulations today and yesterday. And they are so good at combining that campaigning with judicial review. So that's them outside the Royal Courts of Justice with a sort of army of supporters, and they couldn't be making the message more clearer. Defend democracy. You can't. The cases about how the Home Secretary, Suella Braverman at the time, just ignored Parliament and put in anti-protest laws regardless. Fundamentally undemocratic. So think about, there'll be key dates that come up in a judicial review. Your hearing date, for example, in the RCJ. What an opportunity to campaign on the issue, get people out there and really raise the profile, because win or lose, it's going to raise the profile of the issue and get people talking about it. And that is the pressure of that, even just going into court, even if you lose, can prompt real change. And this is my last slide. I'm sorry if I've gone over time. I have a little. You'll get these slides, but I just wanted to give you a few examples of how big judicial review can be, so you get excited. It can get rid of discriminatory regulations altogether. It can close down unlawful hotels for unaccompanied asylum-seeking children. The Miranda judgment that you probably heard about, the horrible Miranda policy, that was judicial review that challenged that. So it's a really powerful tool, and I hope this evening's seminar helps you think about how you could get involved in judicial review. We need more Davids, we need more Abigails, we need more of you to sort of understand and get involved in asserting your rights through judicial review, because it's such an important, powerful remedy. Thank you.
Thank you, Ollie. We have an opportunity for some question and answers now. So is there anybody who'd like to kick us off with a question from the floor? So we have Reg. Oh, he's just going to come to the front and sign his question and try and climb over our chairs.
Sorry.
Thank you very much to the panel. It was a great presentation. It's been a great experience this evening. My name is Reg Cobb, CEO of Deaf Plus. I just want to say I very much appreciate the work that you've been engaged in, and also David, thanks for your case too. You talked about legal challenge being brought by the claimant, and also that the first step is to talk to a lawyer. So my question is, how can our staff at Deaf Plus, we have a team of advisors, often things come up in their cases and there are potential for it to be a legal case that's raised. The question is then, what would our staff do for the first stop to book an interpreter to talk to the lawyer? What would you advise? How can we take issues that arise in our line of work forwards to the legal phase?
I'll just wait for Reg to take his seat. Thank you very much for your question, Reg. And actually, I would just wrap that up. We've had questions from people online. A few people now have mentioned whose responsibility is it to provide and pay for sign language interpreters as a deaf person if you want to go to a solicitor. So that's pretty much the same question. But if I can ask my colleagues if they could answer that question.
Shall I have a go first? I think there are a couple of parts to that question, those questions. There's one about how your caseworkers or your organisation can get public law advice. And then there's individuals who need legal advice, how they can access it and in an accessible way. Part of what we want to do today is start a conversation to get the solicitors in the room with your organisation and other organisations to build those connections so that there are solicitors that you can email with queries. And Abigail's organisation works closely with various different public law solicitors and have built those relationships. And maybe Abigail could maybe speak more about how that happens. But we want to create a sort of ongoing dialogue so that this isn't just a one-off seminar. It's if you spot something, you can come to a lawyer and we can talk about it and work out what to do. And our main priority is breaking down that barrier. So that is a case of getting lawyers in the room with you guys and building up those personal relationships so that we can just have conversations more informally. And then if there is something, take it to the next stage with a client, etc., and try and get funding in place, maybe. In terms of interpreters, absolutely. Solicitors should be providing an interpreter. They are service providers ultimately, and they should be providing if apart from anything else. Do you want to be working with a solicitor who makes it inaccessible for you? I mean, that would be a big no-no for starters. How can they properly challenge discriminatory treatment if they perpetrate it themselves? Legal aid is actually quite good in this in some ways, because the legal aid agency has disbursements for interpreters. Many of the clients that we work with, in particular, may not speak English as a first language because they're an asylum seeker. So without question, the legal aid agency pays for an interpreter. BSL interpreters should be exactly the same principle in terms of a funding disbursement from the legal aid agency. Abigail, do you want to speak about?
Yeah, well, first of all, if an issue arose within the work that we do, but obviously, as I said, it's predominantly education rights for deaf children and young people from 0 to 25, then sometimes we can be that sort of link, and we have the interpreting services, and we support families and deaf parents in trying to be that go-between in accessing that advice from our pro bono partners. In terms of the pro bono partners themselves, what we tend to find is we started many years back with certain firms and certain counsel, and whenever we sort of work with them, I think they get so enthused by the work that even when they then move or they get promoted, move either firm or chambers, they're often really keen to carry on the work. And particularly we get in some of education work, we get trainee solicitors, and then as they move and then they get more confident in some of that work. Yeah, we've had some, I don't, almost, well, very persuasively wanting to sort of us to expand our network for them to continue working with us. So it's great from our perspective, but yeah, so it sort of grows organically, but the number of lawyers that we're working with is certainly on the rise.
And David has also just passed me a note to say that Sign Video has a BSL VRS directory that shows a list of solicitors firms who are willing to have that initial engagement using VRS interpreters. So that's well worth knowing for those of you who have Sign Video.
And we could add that to the email with.
Yes, and as Ollie says, we will add that to the email that we send out with the slides. We can add the link to that and the other information that we're sharing this evening. Any more questions? I saw lots of hands. So can I say 1, 2, 3? Do you want to come?
I'm speaking.
Lovely, right.
I do sign, but my signing level is so low that it would be embarrassing for everybody, including me. My name's Dawn, and I'm with Deaf and Equal, and we advocate and mediate for deaf clients suffering from discrimination, as well as provide training for the companies and organisations that are actually discriminating against them to try and make sure it doesn't happen in the future. But when that goes wrong, they have a real problem because they're trying to access solicitors that have got literally no idea of what it is to be deaf and the very many ways there are to be deaf. They don't know the difference between someone that's hard of hearing or someone that's culturally deaf. And I'm wondering whether there's any resources or any availability that for like a deaf-friendly solicitors group, so that we can direct people not only to somebody that might be happy to take something on pro bono, but somebody that actually has got the first idea of what it is that they're complaining about. And a lot of the issues being that they're culturally deaf, they don't identify as somebody that's disabled. They don't want to be treated as a disabled person. And quite often the first solicitor they go to is almost like a, oh, there, I'm really, oh, poor you.
Yeah.
I'm ever so sorry you're deaf.
Yes.
Well, that's just horrific. They don't want that. So over to you. If that exists, I would really like to know about it so that I can pass those details on to our clients.
Yes, thank you for the question. I've got somebody who's desperate.
Just following on from that,
Yes.
it's very, very early, but it's something that I'm about to set up.
Oh, brilliant. But let's meet the chat.
We've started looking.
Sorry, can I ask, what's your name?
Sorry, I'm Amy Wallhead. I'm from Culver Law. I'm a wills and probate solicitor, trying to be the first deaf-friendly law firm. So we have Sign Video and Sign In, what have you. I appreciate it's a different area of law, but it is something that we're looking at. So yeah, we'll catch up afterwards.
Thank you very much. I can also say that in discussions with, I'm sure they won't mind me saying, in discussions with several leaders of sort of deaf civic society, different organisations, we are looking to come together and set up a quarterly meeting where the different charities in the deaf space, we can get together and discuss exactly issues of this sort. I know pretty high up on that agenda of what we'd like to do to start with is to get some funding to be able to provide some deaf awareness exactly for that point to a range of solicitors.
It's not just the solicitors, it's the judges, it's the tribunal panels, barristers, the court clerks. I've been to cases where they've got an interpreter signing away for somebody that needs a speech to text reporter. They don't sign at all, and they've come out halfway and think, I've got no clue what's going on. They just take it as standard that there must be an interpreter at every case. They don't realise the interpreter's been booked for them. They don't sign.
Yes. I mean, that's why I think in many ways it's absolutely fine. But that's why I think this event is so important. And I, you know, as Ollie mentioned in his presentation, this is just the start, really. We need to have more events like this. We really need to connect.
I mean, access via subtitles.
Yeah. But events like this are what's so important. David's just mentioning, for example, you can look at the Zoom that we have today, where we have sign language and we have subtitles available on that as well, to cater for different needs for deaf people that are watching. But clearly there's more to be done, and hopefully this kickstarts a conversation and we can do a lot more moving forward. Yes, sorry. Ashley's going to come forward and ask a question.
Hello, everybody here and remotely. My name's Ashley. Thank you. Sorry, I'll stand back. My name is Ashley Kendall. I just want to go back to a question that was asked previously in terms of access interpreters for deaf people who have experienced discrimination in wider society and are wanting to have a claim. They need to go to a lawyer or a solicitor. And this process, I know you've given us some advice in terms of us needing to get legal advice, and the solicitors firm should be paying for that access. But in reality, I mean, that would be great if that happened. But what we see in the real world is that's not happening. So just to give you a picture of what deaf people's experiences are on a daily basis if they're trying to engage with lawyers. I know one family, a terrible incident happened. It was nothing to do with sign language or discrimination, and so it was just a legal issue. They wanted to sue, and the family members went to 5 different law firms asking whether they would cover the interpreters, and they all said no. So obviously they wanted to drop the case after that because they just felt, oh, this is terrible. And then the father said, I'll pay out of my own pocket. And all 5 of those different law firms still, their response was, no. We'll bring a paper and pen, we'll engage in that kind of way. That's how we'll communicate. That's a reasonable adjustment. That was their interpretation. So in terms of the Equality Act, what people are, even the notion of reasonable adjustment lets us down, and we don't have time to go into that necessarily. But that is what some people are interpreting as a reasonable adjustment. And so that first step, deaf people are experiencing barriers, and if they can't afford to pay for it, then they could spend money hand over fist. But in the real world, we're not getting that adjustment. So it's, the question, I suppose, is for us, what can we do? If we're trying to get legal aid, will that, when we ask for communication needs to be covered, that's often denied as well. So the reality is people do face barriers at the first, hurdles at the first step.
Any comments to this? I'm happy to.
The thing that for me comes to mind is that a lot of the time it is about networking, and then through the network you then know who to contact and who might be able to help, and if they can't, then they might know someone. So I think this is fantastic because it's another opportunity for, and everybody who's attended today and come online, it's another opportunity for us to build on those networks so that if you have instances like this, it always takes a long time. It feels like an eternity to bring change, but it has to start with, I think, everybody knowing if there's obviously the commitment there, and then being able to build from that. I mean, Ollie's, for example, just set up a school exclusions project, which just started similarly. I mean, I don't know why I'm talking about it. Ollie should tell you about it. But what I'm saying is there are ways to basically, through that networking, to know who there is who might be able to help, and in turn, they might be able to get someone if that person can't. So I think that's my sort of immediate response to it. But yeah, Ollie, why don't you explain about?
I mean, I think we as legal profession have a responsibility to up the standard of our colleagues considerably. It's embarrassing that this is the state of affairs, and like truly shocking. That, and it's something that we will need to raise with the SRA, the listed regulatory authority, the Bar Standards Board. All of these organisations should be prioritising making sure that their members are not discriminating. It's really that basic. And maybe, I know Matthew wants to create a sort of forum going on about how we just sort of keep any momentum from this evening going and do the networking that Nicola's saying. I think from what is being said today, that's sort of the prerequisite to getting anything done, is actually getting over the ignorance in our profession, and the reluctance to actually put in place reasonable adjustments. And I think having sort of lists of like inclusive and sort of ones that know about reasonableness and are prepared to make it is a step in the right direction. And sort of having sort of the ones that are good identified so that people know which ones are good to go to. But there needs to be a lot longer list, and it needs to cover everything from wills and trusts, which I know nothing about, to like breach of contract claims or whatever. The like discrimination practitioners should be better.
I think Ashley's made a significant point, really. If I think back to RAD and their law centres, I mean, you know, maybe it wasn't the perfect solution, but it was a solicitor, there was funding, and then the funding, I don't want to go on about it, but the funding was ceased. But sadly, that provision was then gone. There's a disability court service. There is a national fund available. It's limited, but there is some funding. In my view, the government should recognise this is an issue, recognise that there's a gap. They're saying there needs to be a national fund for disabled and deaf people, so they're properly funded to make sure that things are fully accessible, rather than relying on individual solicitors. I mean, in some way, that's about fairness, right? And again, this then comes back to, as Nicola said, and Ollie has said, and others, campaigning as well as using the legal route. I mean, hopefully in the future, maybe it will be important for us to be able to do that. Deaf people will have access to solicitors without discrimination. So I just wanted to add as well, I think for a long time there's been this gap. So there's the legal sphere and then there's the deaf community. And I think for many years, deaf people have felt this intense frustration as, I think as Ollie said, the smell test. You know it's wrong, we know it's wrong. We've all known this for a long time. And I think there's been this real barrier to be able to move forward on it. And I think today is the first step. It's about building partnerships. It's about deaf organisations, charities, campaigners, and also us within the legal profession, thinking about how we can move forward to prevent these ills that have befallen deaf people over the years. Because some things are about campaigning, some things are about other appeals or claims that we want to bring. I don't want this to be a tokenistic thing. I don't want this to be a one-off event. I don't want anything to not come as a legacy from this. I want us to be able to work together.
I am sorry to say, we don't have any more time for presentations tonight. I've been told that we have to finish. But I know there's a lot more questions. There's lots of questions online. I'm so sorry to everybody on Zoom who's asked questions that we haven't had time to answer. But you've got our email address. If people have got ideas or questions, please do email. And really, all that's left for me to say is say thank you to the people who's online. I'll send a feedback form to the people who attended online as well. Please do give us your feedback. That'll be really useful for us to think about how we frame future events. And also the people who are here and online will send you the slides. When I send you the slides, there'll also be a link to feedback. We really would value your feedback because there's been something that's been useful and beneficial. We'd really like to do more of it. So the people who are here in the room, there's some food. It's probably cold. It's been so long. There's plenty of drinks available and it's an excellent opportunity for us to network. So I'll see you downstairs. Thank you so much.